Features of Indian Federation. Ambedkar compared the Indian Federation not only with that of the USA, but also with other existing federations. By comparing different countries' constitutions, Ambedkar discusses the features of Indian federalism such as rigid versus flexible constitution, single judiciary, division of power, freedom of states with strong emergency power residing with the union government, rigidity and flexibility of the constitution. Ambedkar argued this is not the only difference between the proposed Indian Federation and other federations. Federalism is described as a weak, if not ineffective, form of government. There are two weaknesses from which federation is alleged to suffer. One is rigidity, and the other is legalism. That these faults are inherent in federalism, there can be no dispute. A federal constitution cannot but be a written constitution, and a written constitution must necessarily be a rigid constitution. A federal constitution means division of sovereignty by no less a sanction than that of the law of the constitution between the federal government and the states, with two necessary consequences: one, that any invasion by the federal government in the field assigned to the states and vice versa is a breach of the constitution, and two, such breach is a justifiable matter to be determined by the judiciary only. This being the nature of federalism, a federal constitution has been found in a pronounced form in the Constitution of the United States of America. In order to avoid rigidity and legalism from federalism, Ambedkar divided the articles of Constitution into two groups. The second means adopted to avoid rigidity and legalism is the provision for facility with which the Constitution could be amended. The provisions of the Constitution relating to the amendment of the Constitution divide the articles of the Constitution into two groups. In the one group are placed articles relating to a. the distribution of legislative powers between the center and the states, b. the representation of the states in Parliament, and c. the powers of the courts. All other articles are placed in another group. Articles placed in the second group cover a very large part of the Constitution and can be amended by Parliament by a double majority, namely, a majority of not less than 2/3 of the members of each House present and voting, and by a majority of the total membership of each House. The amendment of these articles does not require ratification by the states. It is only in those articles which are placed in Group 1 that an additional safeguard of ratification by the states is introduced. One can therefore safely say that the Indian Federation will not suffer from the faults of rigidity or legalism. Its distinguishing feature is that it is a flexible federation. Division of authority. Ambedkar points out that the division of authority between legislature, executive and judiciary makes the Indian Constitution different from other constitutions. However, this division of authority might create chaos. So Ambedkar opines that a single judiciary, common all India services and uniform civil, criminal, fundamental laws shall bring in uniformity in the Indian Federation. He wrote, there is another special feature of the proposed Indian Federation which distinguishes it from other federations. A federation being a dual polity based on divided authority with separate legislative, executive and judicial powers for each of the two polities is bound to produce diversity in laws, in administration and in judicial protection. Up to a certain point this diversity does not matter. It may be welcomed as being an attempt to accommodate the powers of government to local needs and local circumstances. But this very diversity, when it goes beyond a certain point, is capable of producing chaos and has produced chaos in many federal states. One has only to imagine 20 different laws if we have 20 states in the Union, of marriage, of divorce, of inheritance of property, family relations, contracts, torts, crimes, weights and measures, of bills and cheques, banking and commerce, of procedures for obtaining justice, and in the standards and methods of administration. Such a state of affairs not only weakens the state, but becomes intolerant to the citizen who moves from state to state only to find that what is lawful in one state is not lawful in another. The draft constitution has sought to forge means and methods whereby India will have federation and at the same time will have uniformity in all basic matters which are essential to maintain the unity of the country. The means adopted by the draft constitution are 3. 1. A single judiciary. 2. Uniformity in fundamental laws, civil and criminal. and 3. A common all India civil service to man important posts. Amending the Constitution. Ambedkar was aware that the provisions relating to amendment of the Constitution have come in for a virulent attack at the hands of the critics of the draft Constitution. It is said that the provisions contained in the draft make amendment difficult. It is proposed that the Constitution should be amendable by a simple majority at least for some years. The argument is subtle and ingenious. It is said that this Constituent Assembly is not elected on adult suffrage, while the future Parliament will be elected on adult suffrage, and yet the former has been given the right to pass the Constitution by a simple majority, while the latter has been denied the same right. It is paraded as one of the absurdities of the draft Constitution. I must repudiate the charge, because it is without foundation. To know how simple are the provisions of the draft Constitution in respect of amending the Constitution, one has only to study the provisions for amendment contained in the American and Australian Constitutions. Compared to them, those contained in the draft Constitution will be found to be the simplest. The draft Constitution has eliminated the elaborate and difficult procedures such as a decision by a convention or a referendum. The powers of amendment are left with the legislature, central and provincial. It is only for amendments of specific matters, and they are only few, that the ratification of the state legislatures is required. All other articles of the Constitution are left to be amended by Parliament. The only limitation is that it shall be done by a majority of not less than 2/3 of the members of each house present and voting and a majority of the total membership of each house. It is difficult to conceive a simpler method of amending the Constitution. After answering all criticisms against the draft Constitution, Ambedkar presented it to the Constituent Assembly. I believe I have dealt with all the adverse criticisms that have been leveled against the draft Constitution as settled by the drafting committee. I don't think that I have left out any important comment or criticism that has been made during the last 8 months during which the Constitution has been before the public. It is for the Constituent Assembly to decide whether they will accept the Constitution as settled by the drafting committee or whether they shall alter it before passing it.